Good morning and welcome to MHC's IP Masterclass on the 26th of April, which is actually International World IP Day. My name is Jerry Kelly and I'm the head of IP at Mason, Hayes & Curran. And I'm joined by Brian McElligott, who's a partner in the team, and by Eimear O'Brien, a senior associate. And I'm going to run through some developments in case law in the area of IP over the last year or so. Eimear's then going to talk about some clearance searches and what you should look out for in trying to clear brands. And then Brian's going to talk about some recent developments in AI. There is a Q&A function in the Zoom, so please feel free to use that and we'll pick up questions at the end. So just to kick off my side of the talk, I'm going to deal with three main areas: trademarks, copyrights, and patents. And in the area of trademarks, the first case I'm going to talk about is the recent news events in the Marks and Spencer's taking on Aldi in respect of Colin the Caterpillar cake and Aldi's version called Cuthbert. And what's interesting about this is it's not sold in Ireland, so these proceedings are only in the UK and they've only started, so there isn't any real development to talk about. But what's interesting in it is the line that Marks and Spencer's has been selling this for 30 years. They have trademarks. And whilst there may not be a likelihood of confusion, perhaps, between the two, there is an element of the claim being brought in respect of the reputation of Colin the Caterpillar and Aldi taking unfair advantage of that reputation through what's called free riding, etc. So it'll be interesting to see how that case progresses, and I'll update you obviously in the next session. What I want to also look at is an interesting development in respect of Lionel Messi's 9-year battle to obtain his trademark. He applied for it in respect of various sporting goods and clothing, and it was objected to by a Spanish cycling company called Massey. And as you can see, Massey and Messi sound very similar, look very similar. But what's really interesting about this case is that the Court of Justice ultimately held that the fame and reputation of Lionel Messi is well known, didn't need to be provided by way of evidence. And that notoriety and fame meant that there was a significant conceptual difference between Massey and Messi, such that any visual or aural sound-alike similarities could be ignored, and therefore the trademark was allowed to progress. Another development in respect of secondhand cars, and we've seen cases before in previous masterclasses around whether use is being made of particular trademarks. Here, the Ferrari Testarossa was sold for a short period between 1984 and 1996. Ferrari had filed Testarossa as a trademark, but hadn't used it since 96 on new cars. And I suppose we all know that we're entitled to sell goods that have trademarks on it in the sort of second-hand sense because the trademark rights have been exhausted. But here what was interesting is that the court was prepared to consider that the sale by Ferrari of second-hand Testarossas, in other words, giving it a badge of origin and originality, and that it is a sort of what it is at Ferrari Testarossa, that use could be considered genuine use to prevent the mark being revoked for non-use for a 5-year period. Then looking at another case in respect of bourbon, which is something close to my heart, I can collect a little bit of it, but effectively Eagle Rare is a type of bourbon that Buffalo Trace does, and another bourbon was set up under American Eagle. Now, they don't look very similar. Both obviously have the word Eagle, but what was interesting here is that the court in the UK held and looked at how bourbon is sold by distillers, in the sense of there are various different iterations, be it a barrel finish in a port cask, a sherry cask, be it a special reserve, be it a cask strength. And for that reason, there can be variations in the name. Jack Daniels and Gentleman Jack, for example. And so for that reason, it was considered that an American Eagle would be confused as coming from the same undertaking that provides Eagle Rare, and therefore there was a likelihood of confusion. I'm going to look at the issue of bad faith, because that's come up an awful lot recently. Historically, it was pleaded in cases or oppositions, but never really got too far, because you had to show a level of dishonesty, and you had to show that somebody had acted way beyond what would be normally expected in commercial behaviors. There's been a number of decisions I'm going to go through. The first of which is one of the most famous now, is Sky and Skykick, where Sky, the famous satellite TV company, had registered trademarks under various classes and services of goods and services, which they weren't ultimately going to be using. And certainly to the ones that they were using, they had them in a very, very broad wording. So what was held here by the Court of Justice is that it could be bad faith to draft very broad specifications, and therefore you could partially invalidate a trademark on that basis. So here, ultimately, there was a counterclaim to an infringement action taken by Skykick, who simply just did software. And whilst they partially revoked most of the relevant Sky trademark, they didn't manage to revoke emails and the like, and therefore ultimately there was an infringement. But the issue of bad faith has developed in further case law. And here, Banksy, I suppose, is a famous artist. Nobody obviously knows who he or she is. The whole idea behind it is the anonymity of it. And therefore, that poses difficulty in asserting IP rights, particularly copyright, because obviously to be a copyright owner, you have to identify yourself and assert that copyright. So here that couldn't happen. So Pest Control Limited is the entity that's associated with Banksy, had filed a trademark for the flower thrower image you have there on the screen. And that was held to be invalid on the grounds of bad faith, most notably because it wasn't intended to be used in a trademark sense, but in fact used to effectively, by another means, assert copyright protection through the use of trademarks, and that was held to be bad faith. Another case is to do with the battle between Swatch and Apple. And in this case, one more thing was obviously a famous phrase used by Columbo in the TV series, but also Steve Jobs when they were doing their product launches. He'd start walking off the stage and then turn around and say one more thing, and then obviously introduce something pretty new. Swatch decided to apply for the trademark as a slogan, one more thing. And on that basis, they were challenged by Apple because it was considered to be bad faith by Apple that they were somehow poking fun at, or you trying to use some sort of parody. Now, the hearing officer in the UK agreed, but the court in the UK decided that they would not, they did not see any evidence of parodic use. Just because somebody might file a trademark for what they consider to be useful and it might annoy somebody, it isn't enough to be sort of bad faith. So the application was held to continue. Final case on trademarks is interesting because this involved the Beverly Hills Polo Club trademarks, which were involved in Europe through a Dutch company and in the US. It was a family, and brothers had split the ownership of it. And which often happens is the European entity wasn't happy that people could look on Amazon.com how much the goods were, and obviously figure out that they're cheaper in the States to buy than they are in Europe. So took an infringement action in the UK that Amazon.com was infringing the UK trademark Beverly Hills Polo Club on the basis that Amazon.com was accessible to users here and indeed could ship the goods. Now, ultimately, things were done by Amazon around that and not shipping them, etc. But what's interesting about the case is the issue of whether Amazon.com was specifically targeting users in the UK such that it infringed the UK mark, even though it was the US entity and the US website, predominantly used by US users, but in fact could be obviously viewed by UK users. And here the court, rather interesting, it's probably one of the first decisions from a UK court where they have not followed the Court of Justice. So you can see the Brexit divide already starting. It's been held by the Court of Justice that if you are selling goods in that way from, let's say, the US into Europe, that can be held to be trademark infringement. But here, the UK courts said it was not, because there was no specific targeting on that basis. Then I'm going to move on to copyright. And there's one main theme I'm going to look at here because it's quite interesting from a copyright perspective, what is happening and how copyright can be used to enforce rights, particularly for items, be it clothing and cars, and we'll look at some cases around that. But originally, the laws in many jurisdictions, including Ireland, provide that to the extent that goods are mass produced and they're not artistic works, you can't claim copyright protection. And they effectively try to push you into design law. And design law has, to a large degree, been used by the clothing industry. And indeed, some of you may remember, going back a little while now, the Dunn Stores and Karen Millen case around design rights in clothing. But here the Court of Justice decided that the issue of copyright protection can't be denied simply because it's a mass-produced non-artistic work. You have to go back to basics and look at the fact of whether the work is the author's own intellectual creation, which is the test of originality for copyright. And in this case, it was held that clothing could be, as long as you can identify with precision and objectivity what the features are that are original to the creator, could be protected by copyright. So it has started to open the doors in using copyright protection. And we'll see that in an Italian decision around the concept of store designs. They had the one on the right there, it's Hiko, that effectively, they tried to get a trademark, they were refused, they gave up, and then they tried to assert copyright. And in fact, were successful in doing so, in line with sort of the Court of Justice decisions. Now, interestingly, if they had hung on to the trademark concept, Apple, for example, has managed to trademark its store layout from protection. So it's possible to register it now, but also to use copyright in that way. And we'll see how this develops. Again, we're looking at a decision of the Court of Justice in respect of a functional object. So this has really changed the law, right? There's a fold bike there. And there's nothing obviously artistic or any way about it. And there's a Supreme Court decision in the UK called Lucasfilm and Ainsworth that held that a stormtrooper helmet from the Star Wars movies couldn't be protected by copyright because it was a functional item and had a utility in portraying a film character. That case law now is effectively being overturned by the Court of Justice as far as Ireland is concerned in following it. Because again, focusing on the originality, are there aspects in which an author or creator of this functional object can say it's their own intellectual creation? And indeed, to that extent, it's possible to enforce it. And we'll see again how a Swedish court very recently has allowed Jaguar Land Rover to assert protection in respect of the Jaguar C-Type car. Very few of them were made in 1951 to do the Le Mans 24-hour race at the time. And replica cars were potentially being made. And the court in Sweden, again, following the case law and how it's expanded in the last year or so, held that it is something which, you'll see an image there, can be a creative expression of an individual. You know, conscious the court was that the 1951 race, for example, had many different types of looking cars, so it doesn't have to even look like that. And therefore, there was scope and an aspect of actually being able to put some creative expression into the car. So it'll be interesting to see how this now has changed the law and how copyright will be used more and more in enforcing. So finally then, on patents, I'll deal very briefly with a few little developments. The first of which is the Supreme Court decision in Unwired Planet. And what's interesting about that case is that it's to do with standard essential patents in the sort of telecoms industry where there was infringement and invalidity proceedings taken. And it was held that the patent was valid, but it was infringed. And as part of the relief in the case, because it's a standard essential patent that's needed by industry to create iPhones or tablets or whatever the case may be, there has to be a license put in place on fair, reasonable, non-discriminatory or frank terms. And the judge at first instance held that what was required of the infringer, even though it was a UK patent just in the UK, was to take out a global license and indeed have a broader portfolio of patents than may have been involved in the actual case itself. And that was upheld in the Court of Appeal and indeed the Supreme Court on the basis that whilst the judge is deciding infringement on a territorial national basis, the scope of the relief was influenced by the third party body that actually puts these industry terms for licensing in place. There was a particular entity involved, and therefore all the court is doing is effectively using industry practice in the relief, and for that reason it can stay. The next development is just a sort of pharmaceutical patent case, which is relatively interesting in the sense of there was a patent granted which was revoked, and then a divisional patent came along later, which pretty much provided for the same potential infringement. And the question here for the UK courts, or the Patents Court in England and Wales, was whether it's possible to have a second bite of the cherry as a patentee. And whilst you may have not succeeded on the original patent, if you have another patent dealing with same subject matter, a divisional patent in this case, do you get the two bites of the cherry? And here there was a situation where the court held that the costs involved in running the litigation at first instance was about £11 million. And for that reason, it wasn't going to countenance, no matter what arguments about injustice there might be, another trial to take up resources like that in the courts. Finally, then, two developments just in respect of an interesting case around encryption codes on checks. It was held, and you can't get patents for software, mathematical methods, and the like. And here, an encryption code on a check was held to be pretty much a mathematical method, the algorithms used, and for that reason couldn't be patent protected. And then finally, there was a patent that was looked at by the UK courts around a card clash problem where somebody in the contactless world we now live in might have had two cards hit the terminal at the same time. Usually what has to happen is a button is pressed by the user, the retailer, and here this manual process was overridden through a technical solution. And for that reason, it wasn't simply using a sort of a business method or a mathematical method, it was actually obviating a physical step, and for that reason it could be patented. So that's me, and I'm going to hand over now to Eimear. Thank you.
Good morning, everyone, and thank you again for joining us this morning. So in previous webinars, I've looked at the steps of filing a trademark straight through to registration from choosing your jurisdiction. And this morning, I wanted to focus on a pre-filing step that can be really important and really useful. So that's clearance searches. So what am I talking about when I talk about clearance searches? Essentially, before filing a trademark, it's really helpful to look and see if there's any pre-existing rights out there that might pose a problem for you in filing your application or in using your proposed mark in a particular jurisdiction. And these pre-existing rights take two forms. They can be registered rights and unregistered rights. So in this slide, we're looking at registered rights, and they are by far the most easiest to pinpoint, because if somebody has registered a trademark, it's going to be searchable and you're going to be able to find it on the trademark register in the relevant jurisdiction. So for the purposes of this, I've just focused on Ireland, the UK, and the EU, which would be the most common jurisdictions that we'd look at. And all three of these jurisdictions have trademark databases that are searchable to you, to anybody. They're freely accessible and they're quite easy to navigate. So I've included them here. It's the IPOI, the Intellectual Property Office of Ireland for the Irish database. It's the government website that covers the UK trademark database, and for the EU register, that can be found on the EU IPO website. So in the next slide then, I've just taken a screenshot of what appears when you look to search for a trademark on the Irish register. So I've included the direct link at the top. I've done this for all the slides, and this slide deck will be circulated to you afterwards, so you can use it as a reference point if you ever want to go straight through to this page. So you'll see here, this is what you see when you look at a trademark database search on the Irish website. And you can search by particular text, and you can also helpfully search by an applicant or a holder. So if you have a particular competitor that you're concerned about, or you're interested in seeing a particular company or industry and what marks they might have registered, then you can easily search through this function here. In the next slide, I have a screenshot of what appears when you access the UK search. So again, it's a similar type search. You can search by owner. You can also search by keyword, phrase, or image. And the direct link is at the top of the slide there again. And finally, then the EU IPO database, which is called eSearch Plus. And this is probably by far the most useful or broad of search functions across the three. So here you can search for a word, you can drag and drop an image if it's a particular logo that you want to search against. And they also have an advanced search function there that you'll see at just above the top right of the search button. And within that, there are several parameters that you can use to narrow down the search. So those are the three databases that are really easily accessible. And as I said, free to access and free to run any searches that you want on them. So after you've identified any registered rights, the next step then is to see if there might be any unregistered rights. Now, this is by their nature a lot more difficult to try and pinpoint because we're essentially looking to see whether anybody is just using your proposed mark or something similar out there in the world, but having not registered it. So in terms of how best to approach this, the first step will always be a general Google search. And this was difficult, I suppose, a number of years ago, but getting increasingly easier as we move towards the online shopping era. And most commercial entities now will have an online presence, whether it be through a website or through social media. So by a quick Google search in a particular jurisdiction, you can generally get a sense of whether somebody's maybe has a shop up and running, has a website, has a social media presence. Maybe a business has been mentioned in some local papers that have an online presence. So that can be really helpful in identifying uses of the mark. I've also included 3 additional websites here, which might be useful. The first one is CRO, which is the Company Registration Office. And in the CRO website, you can check against registered companies in Ireland. You can also check against registered business names and trading names. And the second website, weare.ie, is the new domain for what was the IEDR, and that is the Irish Domain Registry. So if you want to search and see if somebody has picked up a particular .ie domain, this is the website that you can use. The search function is very straightforward. It's on their homepage. And again, you can check there for the Irish domain and see if anybody has registered a domain with your particular mark. The last one then, whois.com, is where you'd go if you want to search a .co.uk domain or a .com domain. And just to point out, if somebody has registered a company name, a trading name, or a domain name, these aren't the same as a registered trademark. So they might be evidence of use of unregistered right, but they're not comparable with them having a registered trademark on any of the trademark registers in the jurisdictions. So then, when you get to the stage where you want to file your trademark, consider filing a trademark. So for instance, if a client comes to us, they have a particular concern about their trademark and it might be opposed because they might have come across issues. We would start talking to them about running a clearance search, a comprehensive clearance search. And what this involves is a comprehensive review of the registered and the unregistered pre-existing rights, like I mentioned. So it would be a search for registered rights across all the relevant jurisdictions. It'd be a search for unregistered rights insofar as we could locate them in all the relevant jurisdictions. And then we take any red flags that we'd find, any prior rights that we think might be an issue for you, and we'd analyze them individually based on the risk of an objection to your use or an opposition to your application. And you might rightly ask, what is the benefit and what is the difference between the type of high-level searches you can do on your own at the very outset and this comprehensive clearance report that your trademark agent will be able to provide you with? So what I set out here is, I suppose, the difference between the two. And the first is, for the comprehensive clearance search that we would run, the search can be tailored to specific classes. And that's, you may have the benefit of knowing the classes that you want to file in, but a lot of the time you mightn't be at that stage yet. And usually before we file a trademark for a client, we'll work with them in determining what is the most appropriate specification. And by that I mean, what are the appropriate classes of goods and services for them to file the trademark in? Because there are 45 classes in total, so there are quite a lot. And depending on the type of area that you want to use the mark in, or may wish to use the mark in, in the near future, there could be anywhere from 1 to probably on average 3 or 4 classes that you might want to cover. So the benefit of running this search at this point is that we'll be able to tailor our search to your specific classes. Because of course, if somebody could be using an identical trademark to you, but they could be using it in an industry that is not similar at all and does not affect yours, and therefore we'd be able to tell you that that is low risk and wouldn't pose a problem for you. So second, I've said the scope of the search includes non-identical marks, and this is a huge benefit. So when you're running your high-level searches in the register yourself, you usually put in the word and you'll get back identical searches or searches that include the trademark, but in its identical way that you have written it. Now, a huge benefit of running this comprehensive search is that it will also pick up similar trademarks. And how we do this is we will engage a third party who runs a very comprehensive search of the relevant registers, and they pick up anything that potentially starts with the same string of letters, ends with the same string of letters. Really usefully, they pick up anything that's phonetically similar. So say, for instance, in the Messi and Massey case that Gerard discussed, that, for instance, that would have been picked up, Messi and Massey, as being phonetically similar. It's particularly useful for the EU IPO database because, of course, you have trademark applications that are being filed in different languages. And you can, even though the spelling could be entirely different, they could be phonetically identical and they will be picked up in that search as well. So you have an analysis then of the risk based on each individual mark. So what we'll do in that instance is we look at all the red flags, as I say, that we have found, any potentially problematic prior rights. We'll look at the particular marks themselves. We'll compare the signs, see if they are similar or highly similar or identical and might pose a problem. We'll look at the specification of the existing trademark, the existing right, and also your proposed specification, and see if there's any overlap and similarity and if it might be a problem. And we'll be able to look at the owner of the existing mark, because sometimes that can give you an indication on whether or not they might be particularly aggressive in defending their mark or not. And finally, an indication of the potential options to avoid a successful opposition. So for instance, we might be able to tell you that a trademark is soon going to expire, and it might be worth waiting to see whether or not it is renewed. Of course, if it expires, it will no longer be an issue for you. But we'll also be able to tell, as I mentioned, if a particular trademark owner has been aggressive in the past in defending their trademark, if a particular identical mark has reached registration with any difficulties. So has it been opposed or who opposed it? That might give you an indication of who might be likely to oppose your application. And options about whether or not we think specifications within classes are similar or maybe dissimilar enough to approach a previous owner and reach agreement on coexistence. And we'll be able to advise on all of those different aspects as part of the clearance report. So I suppose the take-home message in regard to clearance searches is that do be aware and do utilize the search functions that are available to you, particularly at the very start of considering different brands. As I said, they're free to use, very easy to use, and they can help you hone down your mark. But then if you can continue to have a slight concern about a particular mark, it can be very useful and a very good comprehensive option to consider the formal clearance report, which your trademark agent can provide for you. So finally, I also wanted to include a Brexit update slide. I know many of you will be familiar with the trademark position with regard to Brexit and will have received communications on it already. But as the deadlines and timeframes are still running, I thought it was no harm to include just a summary update here on this slide. So as we know, from the 1st of January 2021, or this year, EUTMs will no longer protect trademarks in the UK. And so what that meant was that on the 1st of January 2021, the UK IPO created clones or comparable national trademarks of every existing registered EUTM on the EU database. And for existing EUTM applications, what that meant was that if your application was only pending on that date, you didn't automatically get a UK registration, and you still won't. What happens is you have until the 31st of September 2021 to apply for comparable UK registration. It will be identical in every respect. You'll still be able to benefit from your EU filing date, but you will have to pay the UK application fee when you're requesting that. So in terms of what to bear in mind, I suppose, on the UK marks, if you have any existing registrations, there's nothing for you to do until they reach expiry, and then you'll be paying your renewal fee to the UK office for that national mark. If you have any pending registrations or registrations that have just recently reached registration in the EU, then it's time to be looking at whether or not you want to apply for your comparable mark by the 31st of September. And if you have any new applications that you want to file, just bear in mind that the EUTM application will not cover the UK, and you'll have to consider doing a separate UK national mark. So I hope that was helpful for you, and I'm going to pass you over now to my colleague Brian, who's going to discuss AI.
Thanks very much, Eimear, and hello everybody. I'm delighted to chat to you today about some AI changes. First of all, if I can apologize in advance for any low-level hum you may hear in the background. That's my neighbor has decided in his infinite wisdom today to take on some demolition works. I think there's two reasons I want to talk to you about AI today. The first is that today is World IP Day, and the theme of World IP Day today is all about the links between innovation and intellectual property, which brings me on to the second piece, which is the publication this week, this Wednesday around noon, of the first draft regulation of AI by the EU Commission, which many people will say will actually go on to stifle innovation. So there's a link there between the two. The key points, I think, of this new law, and if you kind of get a very little neat summary up front of the whole thing, are as follows. The first is that it's a regulation, and as many of you are in in-house roles, you'll understand completely that a regulation means that the law will be directly effective in each of the member states once it does become law. It also means that the design of a regulation is that it will have horizontal application, meaning it will hit every single sector. However, once you get into the detail of the articles themselves, you'll see that it's actually really designed to hit certain sectors and certain uses, and then vast swathes of AI will not be affected by this at all. The second thing to note is that there are significant penalties for non-compliance. These penalties are higher than those under GDPR. The third piece to note is that it's going to introduce a new conformity regime, which would be not unlike CE marking and that's applicable to medical devices for particular high-risk uses, not all uses. I can't emphasize that enough. And it's because this conformity regime is coming into place that there will be a lot of, I suppose, anticipation in the build-up to the regulation landing. The regulation will be handed out to each member state to do their own bit in every single member state. And so because of that, you need to introduce a new governance framework so that all the member states can be on message, I suppose, when they deliver it and implement it. And because of that, there's an introduction of a new EU-wide governance framework, and it's not unlike that one that's in GDPR. Finally, there's significant concern, and you will read a lot about this in the press at the moment, around this new regulation being another layer of regulation for those people working in all forms of tech, and that's stifling innovation. And again, a particular impact on SMEs, which is very important from our perspective here in Ireland, given that the vast majority of our tech and our innovation comes from local SMEs. So let's first of all look at the scope. Broadly speaking, this picture here gives you kind of a very high level view of who it applies to. Within the map, you see users and providers of AI. They are going to be hit with this regulation, again, subject to the type of use they're making of their AI. But more interestingly, if you look at the top left there, if you see providers in the US and UK, take for example, let's say somebody who is the owner of a medical device, and that medical device has some aspect of AI in it. If they're selling the medical device from the UK or from the US, and they have no footprint at all in the EU, provided they're selling the device into the EU, they will be regulated. And then there's a final category of providers and users that will also be regulated to the extent that their use of AI has an effect on us, the consumers in the EU. The key actors in this whole systems are 4 categories broadly: providers, users, importers, and distributors. The providers, meaning the product owners or the developers from day one, will be those that will be mostly affected by this regulation, and they'll feel the full form of all the obligations. Users does not mean you and me. User means people in a professional sense. So take the example of the medical device again. If you are the professional user in the hospital deploying that medical device, you will be regulated under this and will have significant obligations on you. Importers and distributors, it's interesting in that they will have obligations with regard to almost overseeing that the provider has done his job. The provider has obligations with regard to labeling and instructions, etc. And the importer and the distributor will actually be obliged to make sure that those things are implemented with regard to the product. So you can see how this could be quite heavy regulation for those parties also. Now, on the next slide, what I'm going to show you is a definition of AI system, and it's the core or the kernel piece to the regulation. If you don't understand what an AI system is, you don't know what's going to be regulated. And it's relatively complex. So I want to give you just a little look at it before I speak about it. So what it is software at its core. Note, it's not hardware. It's developed using a particular type of well-known AI systems. It's for a given set of human-defined objectives, which generates outputs such as content, predictions, recommendations, etc. And those influence real or virtual environments. And it's probably useful to take an example here. Think of, let's say, the TikTok algorithm or the Netflix algorithm, and let's run the process. Is it software? Yes. Was it developed using machine learning? Absolutely. Is it for a given set of defined human objectives? Absolutely. Is it to generate outputs such as recommendations or decisions? Yes. And do those influence real or virtual environments? Well, they certainly influence virtual environments, and they also possibly influence real environments if you take the example of maybe advertising on TikTok. So both of those and those systems are classed as an AI system. So does that mean then that they're going to be regulated? The answer is not necessarily. And on this next slide, I'm going to show you another pyramid, and this talks about the various strata of risk judged under this regulation. So at the top of this 4 tiers are prohibited uses, and we'll speak a bit more about those in the next slide. Beneath that, we have high-risk AI uses, and the bulk of this regulation is targeted at AI systems sitting in that bracket there. Beneath that are limited risk uses, and the examples that are given here are things like chatbots and deepfakes. The obligations on this category of AI system are relatively light, and they are restricted to transparency obligations. So you just need to tell the user you're dealing with a chatbot on the face of it, which vast majority of them do from what I can see already anyway. When it comes to deepfakes, it's a similar thing. Just have to label that, you know, whatever the short video you're looking at of Tom Cruise is not him actually in fact, but rather someone has posted it. An interesting derogation there is that parodies using deepfakes don't necessarily need to label. The final category then is deemed minimal risk, and they will basically not have much obligations at all, if any, under this regulation. Examples given here are things like spam filters and AI deployed in video games. Prohibited uses are getting a lot of press in the last couple of days, particularly The third one on the list there, real-time remote biometric surveillance in public spaces for law enforcement purposes. So the line here is they are banned unless, and there's a few limited exceptions. And one of them would be something that came to mind last week, where that was that cry alert issued by the Gardaí for that 14-year-old girl who was deemed missing in the north, I think. And so in that case, maybe the Gardaí, if they applied to court and were successful, would be allowed to deploy computer vision technology, let's say in the cameras in Belfast, to try to track her down. Social scoring is deemed absolute no-no and will not be allowed, such as also AI systems that deploy subliminal techniques to materially distort a person's behavior, and AI systems that exploit any of the vulnerabilities of a specific group of persons in order to materially distort the behavior of a person. An example that comes to mind there might be targeted ads at people in a vulnerable group, such as gambling ads targeted at people who are vulnerable there. So that's the prohibited uses, the red bit at the top of the pyramid. The next bit down, the bulk of the regulation is hitting these guys and these particular sectors. So it's health, aviation, travel, think things like autonomous vehicles, remote biometric space. So the remote biometric surveillance that is derogated from the prohibition slots into this category of high risk, and also safety components in utilities, etc. So those sectors are automatically deemed high risk and will be regulated as such. On this slide, we're looking at automatically deemed high risk uses as opposed to sectors. So recruitment, education, creditworthiness, applications in the law. The one that jumps out at me there, I guess, is assessments or grading in education. And straight away what comes to mind is the Leaving Cert and the use of AI technology to grade in the Leaving Cert. It will be automatically deemed to be high risk. And in this case, it will be subject to self-assessment by the owners of that tech in order to hit the conformity standards that will allow it to get on to the market. So that's I suppose, the high level view of all the key targets of this legislation, the prohibited risk, the high risk, and the limited risk and the minimal risk. And the high risk people being those that need to get on board with conformity assessments, reviewing what they're doing, hitting certain targets with regard to their data, their security, their transparency, human oversight, and they will have to jump through a number of hoops to get onto the market. With this, a couple of other points worth noting is things like governance, and I'd mentioned this a little at the top, where a new governance regime will need to be put in place, not unlike that with regard to, let's say, supervisory authorities across the EU dealing with data protection matters, because each member state will have to do its own bit when it comes to regulating AI in its own jurisdiction. There are specific measures put in place to encourage SMEs or to help SMEs out. Now, from what I can see, it's only one article of the whole regulation, and so it's may only be like a tip of the hat to this because not massively significant for SMEs, and we'll have to see how this will play out. But broadly speaking, it's looking at application fees for them when it comes to conformity assessments and maybe dropping those fees. When it comes to things called regulatory sandboxes, which are supposed to be innovation drivers, it will be to allow SMEs priority access to these innovation sandboxes. Another key point to look out for is the penalties. They are gathering a lot of chat at the moment. At the highest level, it's a 30 million fine for infringements, or a 6% fine based on global annual turnover of a company. That drops to a 20 million 4% and a 10 million 2% based on grading for different types of issues. On the press release on Wednesday this week, the Commission had said their approach will be a graduated response, issuing notices for compliance. If they're failed to be complying with issuing prohibition notices, and only finally, if they aren't complied with, maybe they'll then look at fines. So you can see it will be graduated. AI providers who are on the market will be very interested to hear how the implementation of the legislation is going to work, or grandfathering provisions. At the moment, it looks like if you currently have your AI device or product or software on the market and it's lawfully there without any issue, you will sail through the initial implementation unless and until you change or update or develop or modify it in a manner that makes a change that's material, and you will have to go back and do the analysis as to whether, well, am I one of these sectors or uses? Am I high risk? Then you have to go through your self-assessment around conformity or go through a particular application route to a third party. As regards next steps, it goes now to the Council and the Parliament, and the live web stream on Wednesday, they were at pains to impress that this is an urgent matter for the Commission and they want to push through as a matter of priority. How long that takes now is another thing. After that, it's anticipated that it will be 2 years before it becomes legislation. So we're looking at 2023. But in the meantime, I think it is absolutely time to start thinking about these big picture issues around scope, fines, high risk or prohibited uses, and getting our minds around to who falls into what and who needs to be preparing. And I'll leave it there and I'll hand back over to Jerry for some Q&A. Thank you.
Thanks, Brian. We'll just do some Q&A. As I said, please feel free to input into the Q&A box if you want. There seems to be a number of AI questions, Brian, anyway, so I might start with you. Do you have an opinion on how a material distortion of behavior might be defined? And the questioner has asked, if YouTube's algorithm gets me to start watching videos about the Norwegian leather industry every day, has that been a material distortion of my behavior?
It's difficult, I suppose, to answer that just yet, but it's supposed to be a material distortion of your behavior that then leads to, I suppose, poor outcomes or risky outcomes that maybe will do damage to either your mental or physical health. So in the particular example you've given there, I don't believe it will hit the threshold, but it's only once we see some more guidance coming out that we'll get a better view on this.
Okay, and there's another question. Does this new law mean that all use of surveillance AI will be banned outright?
No, it's a lot of chatter, as I was saying, about this particular topic at the moment online. And my view is that I'm not at all surprised by this, because surveillance tech is very much a no-no or a very high bar to reach under GDPR already at the moment. So this is not a surprise. But the prohibited aspects of the prohibited uses are defined as real-time biometric used by law enforcement. So it's a very specified type of this type of technology is banned. You can absolutely take it as read that the uses outside that use will automatically fall into the high risk category and may still be very difficult to justify.
Eimear, there's a question here about, should we receive contact from the UK IP office with details of the new UK registration? I presume that's in the Brexit context. I don't think we've received anything yet.
Yeah, so in terms of the clone being created in the 1st of January, the answer is no. You won't receive a notification. You won't receive a new registration certificate from the UK IPO. The first communication you'll receive from them, or your trademark agent, if you have appointed one, will receive, is when that registration comes up from renewal. If you do want to search the register for it, you can. What they've helpfully done is they've used the EU trademark number and they've just put a 9 in front of it. So it will come up on their register as UK 0009 and then followed by the number of the EU trademark. So you can find it that way if you want to just double check that it's there.
Okay, thanks. And there's a question here. When you talk about the Lionel Messi case and it being sort of common knowledge that there's an overriding conceptual similarity, would that extend to famous companies such as Coca-Cola and the like? That's uncertain at the moment. Certainly commentators are wondering whether there will be a judicial notice or sort of the panel notice of how famous like a person or a company could be, and to what extent there would need to be evidence there. So we'll just have to wait and see what the situation is there. But that development is very interesting in the sense of quite a strong visual and sound-alike similarity was there, but could be overcome through conceptual dissimilarity, so to speak, based on not evidence, but actually taking account of what might be considered common knowledge. So we'll just have to see to what extent it does extend. But as I said, that is a Court of Justice decision. So funnily enough, it might actually mean that national courts looking at the issue would be wondering what the issue is, or to what extent it's relevant there. And we might see another actual reference on that to deal with sort of corporate entities. Eimear, what countries can you cover in a clearance search?
So short answer, any country that you might want to consider filing in terms of the clearance report that we prepare at Mason Hayes, the most common one would be to cover Ireland, to cover the EU, which of course applies in Ireland, and it covers international trademarks designating the EU and Ireland. Now, to go outside of those jurisdictions, we have several local contacts in any jurisdiction that we can arrange clearance reports for you through. What I might just mention actually is that an EU search just covers the EU register and not the individual national registers of each member state. So that's just something to bear in mind in order to really rule out the possibility of somebody, say, appearing with an Italian national mark or a French national mark. The individual national registers would have to be searched. That's not generally included in the EU report.
Thanks. I think just one final question, Brian, it's to you. Will this new regulated AI market in the EU cut it off from the rest of the world?
It's a fair point. I suppose what's being asked here is, because products will have to be regulated in a specific fashion in order to get onto the EU market, it will, if you like, artificially create a new AI market in the EU. I think it is possible, yeah, that you'll have fragmentation. You'll have US type markets and an EU type market for specific types of AI, those high risk ones. But if we kind of look to what's happening with privacy, you'll see that consumers tend to want, or are edging their way towards the best for them. And if this turns out to be what the EU project wants it to be, a kind of a trustworthy AI project, well, I suppose you could see a point where the EU would become kind of a gold standard for trustworthy AI products, because they compel those products to be and hit those standards, and therefore, would product makers go, well, why don't you just make one product to that standard and put it on the market elsewhere? I don't know, but I can absolutely see to some arguments around market fragmentation, yes.
Okay, thank you. I think nothing else come through there, and we've gone past the sort of 45 minutes at this stage. So I'd like to thank everybody for attending. I hope there was something of interest in it for everyone. There will be a pop-up survey that's going to come up on your screen. We'd appreciate it if you could take the time to fill that out, and in particular to indicate any topics that you'd like MHC to cover in future webinars, etc. So thanks again, and happy World IP Day.
Thanks very much.
Thank you.